Mr. Beat presents
Supreme Court Briefs.
Washington, D.C., March 1st, 1875. President Ulysses Grant signs the Civil Rights Act of 1875, also known as the Enforcement Act, which grants... which grants everyone equal treatment in public accommodations, public transportation, and jury selection. Public accommodations meant facilities generally used by the public at large, like retail stores, movie theaters, and recreation centers. Hey, I like recreation. The Enforcement Act granted equal treatment in public accommodations even if the facilities were privately owned. Now, please be aware that, first and foremost, the law was meant to protect African Americans, the vast majority of whom had just been freed from slavery just 10 years prior. Well, many governments throughout the country did not enforce the Enforcement Act. Blacks still faced widespread discrimination in facilities all over the country. Often, white owners of facilities would simply not let black customers even enter their establishment. Not only that, racial segregation laws were quickly becoming more common throughout the country, especially in southern states, mostly since the federal government was no longer stopping these laws from happening. These segregation laws were basically like sticking a middle finger to the Enforcement Act. In response, several African Americans sued businesses across the country for discrimination. Specifically, they sued two dudes for refusing to allow people of color to stay at their hotels. They also sued two other dudes for refusing to allow people of color into their theaters. Finally, an African-American family sued the Memphis and Charleston Railroad after they were denied first-class accommodations traveling through Tennessee in 1879. Together, all of these lawsuits later became known as the Civil Rights cases. The Supreme Court decided to take on all 5 of these cases, consolidating them since they were all so similar. They heard oral arguments on March 29th, 1883. No doubt the justices understood that discrimination was taking place. In each and every case, a black person was denied the same accommodations as a white person. However, they did debate whether or not the federal government truly had the authority to prevent private companies from discriminating against customers. In particular, they were looking at the 13th Amendment and the Due Process Clause and Equal Protection Clause of the 14th Amendment. If the 13th and 14th Amendments didn't apply, then the 10th Amendment, which says all power is not granted to the national government, goes to the states or to the people, would. And so the big 2 questions the court considered. Number 1, was the Civil Rights Act of 1875 a legit law under the 13th and 14th Amendments of the Constitution? And number 2, could Congress ban private discrimination? The court said no to both questions. On October 15th, 1883, they announced they had sided with the businesses that were discriminating. It was 8-1. You heard that right. First of all, the court distinguished government and private action. They said, according to the 14th Amendment, the federal government couldn't regulate stuff that was the result of conduct by private individuals, not state law or action. Justice Joseph Bradley wrote the majority opinion, quote, "Positive rights and privileges are undoubtedly secured by the 14th Amendment, but they are secured by way of prohibition against state laws and state proceedings affecting those rights and privileges, and by power given to Congress to legislate for the purpose of carrying such prohibition into effect." Sure, blacks were being discriminated against, but the federal government's hands were tied, man. Because of this, the court said that parts of the Civil Rights Act of 1875 were unconstitutional, and therefore, the 10th Amendment indeed applied. Justice John Marshall Harlan was the only one on the court who disagreed. He later gained the nickname the Great Dissenter, since he often was the lone dissenter, as a matter of fact. Anyway, he argued that the rest of the court's interpretation of the 14th Amendment was too narrow for these cases. He said that hotels, theaters, and railroads, even though they were privately owned, were effectively still in the public realm. Besides, he wrote, quote, "The one underlying purpose of congressional legislation has been to enable the black race to take the rank of mere citizens. The difficulty has been to compel a recognition of their legal right to take that rank and to secure the enjoyment of privileges belonging, under the law, to them as a component part of the people for whose welfare and happiness government is ordained. Well, Harlan may have been ahead of his time, but he wasn't convincing anyone else on the court back then. The civil rights cases led to lots of protests around the country. It almost single-handedly led to Congress no longer actively trying to protect the civil rights of African Americans, and further led to the spread of racial segregation in housing, employment, and public facilities. Over the next 80 years, African Americans would constantly be treated like second-class citizens. Only after the Civil Rights Act of 1964 and the subsequent Supreme Court cases, Heart of Atlanta Motel v. United States and Jones v. Alfred H. Meyer Company, would these cases finally be overturned. I'll see you for the next Supreme Court case, jury. One reason why I made this video is to show you that yes, sometimes progress can get reversed, but it doesn't mean it has to stay reversed. So don't lose hope out there, okay? Speaking of which, I know this series doesn't do that well, but screw it! I want to keep making these videos anyway. So which Supreme Court case would you like for me to cover next? Let me know somewhere. And thanks for staying curious.